Hello, good evening, and welcome to BYJU'S Exam Prep. Welcome to yet another episode of Polity this week, and these are the topics that we shall be discussing today. So let's get started and discuss topic number 1. Shinde Group is the real Shiv Sena, says the Election Commission of India. Now let's try and understand this newspaper article in some detail. Article 324 talks about a constitutional body known as Election Commission of India. Constitution says under Article 324 that superintendence, direction, conduct, control of all elections is vested in this body known as Election Commission of India, which means whether the election to the office of President or Vice President, election to the Lok Sabha and Rajya Sabha, election to the State Legislative Assembly and State Legislative Council, all these elections are conducted by this constitutional body known as the Election Commission of India. But when it comes to the urban local bodies such as municipalities and Panchayati Raj institutions, elections are conducted by the respective state election commissions, which means every state has its own state election commission to organize elections to urban local bodies and Panchayati Raj institutions. But under Article 324, if superintendence, direction, conduct and control of these elections is vested with the Election Commission of India, then Election Commission of India made few rules. For example, election conduct rules. The year was 1961, and symbols order, the year was 1968. What does that mean? Which means holding elections, conducting elections is not the only responsibility of the Election Commission of India. The developments of the past week have told us about two other important roles and functions of the Election Commission of India. Which are these? Number 1, recently governors were appointed to various states and some governors were also shuffled. For example, the governor of Jharkhand, Mr. Ramesh Bais, was transferred to Maharashtra. He is now the governor of the state of Maharashtra. But he did not act on the report of the Election Commission of India, which tells us about one more role which is played by the Election Commission of India. What is that role? Member of a legislative assembly can be disqualified by the governor on various grounds, and one such ground is if this member of the legislative assembly holds an office of profit. Now there was a dispute in Jharkhand. The current chief minister, Mr. Hemant Soren, it is alleged that when he was the mining minister as well, he awarded a mining contract to himself, which basically means an office of profit, and as such should be disqualified by the governor of Jharkhand. But the governor cannot disqualify a legislator on his own. The governor has to refer this matter to the Election Commission of India, and whatever report is presented by the Election Commission of India shall be binding on the governor. It is argued that when this matter of office of profit was referred to the Election Commission of India by the governor of Jharkhand, then a report was also given by the Election Commission of India to the governor. He did not act on this report, which various constitutional experts, at least two former chief election commissioners, have said is unprecedented, which has never happened in the history of independent India. So when he moved out, when the governor of Jharkhand moved out from Jharkhand to Maharashtra, he did not act on this report for 5 months, which basically means that Election Commission of India plays another role apart from organizing elections, which is that it recommends the governor, it recommends the president questions on disqualification, which means a legislator can be disqualified on the grounds of holding an office of profit, on the grounds of if there is change in the nature of citizenship, on the grounds of mental unsoundness, on the ground of if this legislator is adjudged insolvent, bankrupt. On all these grounds, a legislator can be disqualified by the president if you are a legislator of parliament, can be disqualified by the governor if you are a state assembly or legislative council legislator, but you will have to act on the report of the Election Commission of India, which is binding on the Election Commission of India, which is binding on the president or the governor. Role number 2, it also talks about two different factions if it results in a political party and it resolves that dispute. How? Shiv Sena as a political party was formed and established by Balasaheb Thackeray in the year 1966. But last year, there was a dispute. The party split. One faction was led by the former Chief Minister Shri Uddhav Thackeray, and the other faction was led by Shri Eknath Shinde, who is now the Chief Minister of Maharashtra. Now, in this dispute, who gets to have the real name Shiv Sena? Who will get the symbol, bow and arrow of Shiv Sena? Who will get the name? Who will get the symbol? That is decided by the Election Commission of India according to paragraph 15 of the Symbols Order of 1968. And this decision to decide who is the real faction of a political party, who is the real owner of that political party, controller of that political party, that can be decided only and only by the Election Commission of India. In fact, this matter went to the court as well. Sadiq Ali versus Election Commission of India, the year was 1971. And this decision that Election Commission of India will only have the power to decide on who gets the real name of a political party and the symbol of a political party. This power to decide is given to Election Commission of India. Supreme Court in 1971 has upheld paragraph 15 of the Symbols Order of 1968. But then how does Election Commission of India decide which faction is the real political party and will get to use the symbol of that political party? For that, every political party has a constitution, and the copy of this constitution is given to the Election Commission of India. And which is that political party? This political party is a recognized political party. Now listen to me carefully. Any political party, if it wants to contest elections and get the benefits from Election Commission of India, has to register itself with the Election Commission of India. All these political parties are known as registered political parties. But over a period of time, some of these registered political parties may also be recognized by Election Commission of India. Recognized as either the state political party or recognized as the national political party. There are various criteria that you will have to fulfill on the basis of which you can be recognized as a state or a national political party. But what about those political parties which are registered political parties, but which are not recognized as the state or national political party? If there is a dispute, if there are two or more factions of a registered political party, Election Commission of India tells these registered political parties and their factions that you resolve these disputes on your own or you approach the courts in India. So if it's a registered political party, Election Commission of India advises various factions to resolve their disputes on their own or approach the court. But when it comes to a recognized political party, Election Commission of India resolves that dispute and decides to allot symbol and the name to one faction which will be the real political party. And what Election Commission of India does, it takes a look at the constitution and then looks at the organizational strength and looks at the legislative wing as well. According to the constitution of a political party, there are various office bearers, for example, the secretaries, vice presidents, presidents, district authorities. Based on the organizational wing, which faction controls most of these organizational members? On that basis, Election Commission of India decides who is the real faction. Second, on the basis of the legislative wing. For example, which faction of this political party controls the majority in Legislative Assembly, controls the majority in the Lok Sabha. But in this case of Shiv Sena, because Shiv Sena is a recognized political party, a recognized state political party of Maharashtra, the Election Commission of India looked at the constitution but did not look at the organizational majority. It decided that the Shinde faction is the real Shiv Sena and allotted the name and symbol to the Shinde faction of Shiv Sena based on its majority in the legislative wing. Why? Because the Election Commission of India said that the constitution of Shiv Sena was changed in the year 1999. Then the constitution was amended again in 2018. But the changes that were made in 2018, that copy was not given to Election Commission of India. So on the basis of that, we cannot decide that organizationally which faction, whether Shinde faction or the Uddhav Thackeray faction, controls the organization of Shiv Sena. So we cannot decide who is the real faction based on the organizational wing. But we will look at the legislative wing, and there we can clearly see that whether it is Lok Sabha, where 13 of the 18 MPs, they have owed their allegiance, they have supported Mr. Shinde, and in the Assembly, 40 legislators, which means 76% of the legislators of the Shiv Sena support the Shinde faction. And that is how, on the basis of the strength that Shinde faction has in the legislative wing, we decide that the real Shiv Sena is the Shinde faction. You get the name, you get the symbol, bow and the arrow of the Shiv Sena. This has been criticized by Shri Uddhav Thackeray as well, and he has said that I will approach the Supreme Court. Why? Because tomorrow, if there is a political party A, and this political party may be an old political party with century-old legacy, but this political party will have 40 MPs or 40 legislators, it would be easy for a big corporate to buy these MLAs, to buy these legislators, and then control the political party. So basically, this test to decide who is the real faction, who is the real party, should not be decided only on the basis of the majority enjoyed in the legislative wing, but should be decided by the majority that a faction will have in the organization as well. That's what you need to understand from this topic. But now, two more things. For example, the symbols order of 1968, after this order was made, the first high-profile case that was decided by the Election Commission of India was when the Congress party split in 1969. When Congress party, some of the members of the Congress party who are known as syndicate, for example, Mr. K. Kamraj, Mr. Neelam Sanjeeva Reddy, they ousted Shrimati Indira Gandhi from the Congress party, and then the Congress party split. That was the first high-profile case which was decided by the Election Commission of India on the basis of the symbols order of 1968. That can be important for your prelims examination. Prior to the symbols order, it was this Election Conduct Rule 1961, on the basis of which the Election Commission of India would decide on the different factions as to which faction is the real political party. For example, Election Conduct Rules of 1961 was used when the CPIM was recognized by the Election Commission of India in the year 1964. Because in 1964, some of the legislators of the Communist Party of India, belonging to Andhra Pradesh, belonging to Kerala, belonging to West Bengal, they approached the Election Commission of India that please recognize us as a separate political party, and that separate political party will be known as the Communist Party of India Marxist, which basically means that now which faction is the real faction is decided by the Election Commission of India on the basis of the symbols order of 1968, and prior to the symbols order, the Election Commission of India would decide this question on the basis of the Election Conduct Rules of 1961. That is what you need to understand from this topic. Let's look at another column. The spirit of the law lies in this dissenting judgment. Dawoodi Bohras. Dawoodi Bohra is a sect of Shia Islam. Constitution of India under Article 25 talks about individual rights. And under Article 26 talks about group rights. What does that mean? Under Article 25, I have the fundamental right to profess, practice, and propagate my religion, which means it is an individual fundamental right. But under Article 26, this right is given to a religious group, to a religious denomination, that you have the fundamental right to manage your own affairs. That means you may establish a religious institution for religious purposes, for charitable purposes, and you have the fundamental right as a group to manage your own affairs. And Dawoodi Bohra, they have a supreme leader who is known as Al-Dai Al-Mutlaq, a supreme leader. And according to Dawoodi Bohras, this supreme leader has been given a power. And what is that power? A power to excommunicate. What does that mean? That means a member of the Dawoodi Bohra can be expelled from this community, which means you may not be allowed to access the mosque, you may not be allowed to access the burial ground, basically some form of social boycott. Clear? Which means under Article 25, I have an individual fundamental right to practice, propagate, and profess my religion. And under Article 26, group rights are given to a religious denomination that you can manage your own affairs. And managing your own affairs would mean that this Al-Dai Al-Mutlaq has been given the power by the Dawoodi Bohra community that you can excommunicate a member. And there were allegations that who were these members who were excommunicated? Some of these members were those who challenged the leadership of the supreme leader known as Al-Dai Al-Mutlaq. But something happened. The year was 1949 when in Bombay a law was passed. The law was passed to prohibit excommunication. That means you cannot excommunicate a member of any community. Now, one member of the Dawoodi Bohra approached the Supreme Court and said this violates my fundamental right. Particularly, it violates Article 26 of the Constitution, which gives fundamental right to a group that you can manage your own affairs. The year was 1954 when the Supreme Court in a landmark case, Shurur Mutt, it said that there are some essential features of a religion, there are some non-essential features of a religion. Non-essential features will not be protected by the Constitution. Only the essential features of a religion will be protected by the Constitution. Which means based on 1954 judgment, the judges in this country will have the power to decide what are the features which are essential to a religion and what are these features which are non-essential to a religion. And if there are some features which are non-essential, they can be struck down, they will not be given the constitutional protection. And that is what we call doctrine of essentiality or essential religious practices test. The petition filed in the Supreme Court in 1962 by a member of the Dawoodi Bohra, it said that this power of the supreme leader of Dawoodi Bohras to excommunicate a member of Dawoodi Bohra community, this is an essential practice of Dawoodi Bohras, and as such this essential practice should be protected, which means this 1949 law passed in Bombay which prohibits excommunication, this should not apply to Dawoodi Bohras. Why? Because we have a group right under Article 26 wherein we have given the power to the supreme leader that you can excommunicate a member. This law should not apply to the Dawoodi Bohra community. 1962, a 5-judge bench of the Supreme Court, a 5-judge constitution bench of the Supreme Court, by the majority of 4:1, ruled in this favor. Said yes, excommunicating a member from the Dawoodi Bohra community, this is an essential religious practice of the Dawoodi Bohras, which means this power is given to the supreme leader to enforce discipline in the Dawoodi Bohra community, which basically means Article 26, which gives this group a fundamental right to manage its own affairs. This is an essential religious practice of the Dawoodi Bohra community. There was only one judge who dissented, and that judge happened to be the Chief Justice of India, Justice B.P. Sinha. And Justice B.P. Sinha dissented. But something else happened. The year was 1985-86, when this 1962 judgment was challenged. The constitutional validity of this 1962 Supreme Court judgment was challenged in 1986, and this case was pending in the court. And finally, all these years when the case was pending, now on 10th of February 2023, Supreme Court referred this matter to a larger 9-judge bench of the Supreme Court. And this larger 9-judge bench of the Supreme Court was established, set up after the Shabrimala review case. What does that mean? In the year 1986, when this 1962 law was challenged, later on, in the year 2016, another law was passed by Maharashtra called Maharashtra Protection of People from Social Boycott Act. According to this act, excommunication is considered to be a form of social boycott, and all forms of social boycott are prohibited. And it recognizes close to 16 events or 16 cases of social boycott, which means if somebody prohibits a member of your community to access a mosque or a religious institution or a burial ground, this is social boycott, and it has been prohibited under the law passed in the year 2016. Now, recently in the Supreme Court, the petitioner in this case argued that this matter should be referred to a larger 9-judge bench of the Supreme Court because it is hearing the Shabrimala review case. But the advocate who was representing the supreme leader of the Dawoodi Bohra community, he said that this petition should be dismissed. Why? Because this 1986 petition was filed in the Supreme Court to challenge the 1962 judgment. And this 1962 judgment was based on the law passed in the year 1949. But this 1949 law has been overruled, has been replaced by 2016 law, which basically means that you should reject this petition. But the Supreme Court said, no, we will not reject this petition. We will refer this to a larger 9-judge bench of the Supreme Court. Why? Because of two things. Number one, Supreme Court said that individual rights and group rights, individual rights under Article 25, group rights under Article 26. The 1962 judgment did not decide whether group rights have more primacy than individual rights, whether group rights will prevail over individual rights. That is why we have to refer this matter to a larger 9-judge bench of the Supreme Court. Supreme Court said something interesting as well. Supreme Court said the jurisprudence in India has changed after the 1962 judgment. And the jurisprudence has changed that any form of excommunication will have to be tested on the touchstone of constitutional morality. And what is that constitutional morality? For example, in Nas Foundation case, also Navte Johar case, where Supreme Court said homosexuality is not a criminal activity. Homosexuality was decriminalized. Supreme Court said we don't have to look at the morality of the people of India. we have to look at the constitutional morality. And this was also referred to Justice B.P. Sinha when he dissented in the 1962 judgment. In that judgment, he said, even if the power is given, listen to me carefully, even if the power is given to the supreme leader that you can excommunicate a member of your community, although this may be an essential practice of Dawoodi Bohras, but we don't have to look at only this aspect. We have to look at what is going to be the impact of this excommunication on that member who has been expelled from the community. He enjoys rights, and we have to look at what is the constitutional morality. In the sense, we have to look at whether this excommunication will impact the liberty, will impact the equality, will impact the dignity of this individual. Because when you excommunicate a member of a community, you are also not allowing that individual to access mosque, for example, which would violate his Article 25. You are basically imposing social boycott, which violates Article 21, which is right to life and dignity. It violates the dignity of an individual. And dignity is the constitutional morality. Liberty is the constitutional morality. Justice is the constitutional morality. So any form of excommunication will have to be judged on the touchstone of constitutional morality. And that is what Mr. Suhrit Parthasarthi writes, that when the 9-judge bench of the Supreme Court will hear this matter, it will do well if it looks at the dissenting judgment given by Justice B.P. Sinha in the case of 1962. But you might also be wondering, what is this 9-judge bench of the Supreme Court doing? The year was 2018, when a 5-judge bench of the Supreme Court, by the majority of 4:1, it ruled that women of all age groups are allowed to pray at the Sabarimala temple. Why? Because there were rules which prohibited, which barred the entry of women in the age group of 10 to 50 from accessing the sanctum sanctorum of the Sabarimala temple. Some petitioners approached the court saying that this violates Article 25, which is right to practice the religion. It violates Article 17, which talks about untouchability in any form is forbidden, abolished. It violates Article 14, it violates Article 21. And the Supreme Court in 2018 said women of all age groups may be allowed to pray at the Sabarimala temple. But then the year was 2019, when a review petition was filed challenging the Sabarimala verdict. And this case was heard by 5 judges of the Supreme Court, led by Chief Justice of India, Justice Ranjan Gogoi. Normally, when a review petition is filed, it is either accepted or rejected. But this time, 3 judges of the Supreme Court, by the majority, decided that we will keep this review petition pending. We will neither accept this nor reject this. We will keep it pending. Why? Because there are other petitions pending in the Supreme Court which raise similar issues. Which are these similar issues? For example, the denial of entry of Muslim women in dargahs. Muslim women are denied entry inside the dargah, which is similar to the denial of entry of women in the Sabarimala case. So this issue also raises a similar question as raised by Sabarimala case. So we will hear this matter first. Second, female genital mutilation practiced by the Dawoodi Bohra community. They have a belief that when a girl attains the age of 6 or 8, her clitoris is either completely or partially cut. Why? Because they have a belief that this clitoris is the source of all sins. And that is why this clitoris should be either partially or completely cut. That's what is called female genital mutilation. Dawoodi Bohra say this is an essential practice of the Dawoodi Bohra community. Just like the temple authorities in Sabarimala said, it is an essential religious practice of ours to restrict, to deny entry to women of menstruating age from accessing the sanctum sanctorum of the Sabarimala temple. And third, Parsi women if a Parsi woman is marrying a non-Parsi, she is not allowed entry inside the fire temples managed by the Parsi community, because they have the right to excommunicate those women who have married a non-Parsi. The Supreme Court in the Shabarimala review case said that there are 3 other cases which raise similar issues as the issues were raised in the Shabarimala case. Till the time we will hear these cases, we will keep the Shabarimala review petition pending. And for that, in this case, the Supreme Court said that we need to set up a larger 9-judge bench of the Supreme Court, which will answer various questions. Questions such as, should we continue with essential religious practices doctrine? Should the judges be the authority to decide what is essential to a religion, what is not essential to a religion? Question number 2. What is the sweep of this expression? Public order, health, morality. Because under Article 25, you have the fundamental right to profess, practice and propagate your religion. But this is not an absolute fundamental right. This fundamental right can be restricted on the grounds of public order, health and morality. What is the expression of this term morality? Is it the morality of an individual religious group, or is it the constitutional morality? That's question number 2 that this 9-judge bench will have to answer. Question number 3. Various petitions were filed in the Supreme Court challenging some of the religious practices. But these petitions were not filed by the devotees. These petitions were filed by the activists. For example, those petitioners who challenged the ban on the entry of women in Shabarimala, that petition was not filed by those who are the devotees of Lord Ayappa. That petition was filed by the activists. The court, the 9-judge bench of the Supreme Court, will have to now answer whether the Supreme Court can accept public interest litigation filed by non-devotees when it comes to the religious practices. And the Supreme Court will also have to decide what will prevail, an individual right under Article 25 or a group right under Article 26. So these are larger questions that this 9-judge bench of the Supreme Court will have to decide. And to this 9-judge bench of the Supreme Court has now been referred another matter, the 1962 judgment, which gave the right to the supreme leader of the Dawoodi Bohra community that you can excommunicate some members of your community so as to ensure the discipline in that community. That is what you need to understand from this column. The spirit of the law lies in this dissenting judgment. Clear? Let's look at another topic. Governors to various states were appointed by the President of India. But one appointment raised a lot of discussion and debate, and that was of Justice Nazir. Justice Nazir retired as the Supreme Court judgment in January 2023, and within a month of his retirement, he was appointed as the governor of the state of Andhra Pradesh. Some questioned it, some praised it, but let's look at the larger issue. Is Justice Nazir the only former Supreme Court judge to have been appointed as a governor? No. The year was 2014 when Justice Sathasivam, who was the Chief Justice of India, a former Chief Justice of India, was appointed as the governor of Kerala. Before that, Justice Fatima Bibi, she was the judge of the Supreme Court, retired in the year 1992, but she was appointed as the governor of Tamil Nadu in the year 1997. Prior to that, Justice Fazal Ali, he was the judge of the Supreme Court, but he was also appointed later as the judge of Odisha and Assam. In fact, he was also appointed as the chairperson of the States Reorganization Commission, which was set up in the year 1953. So Justice Nazir being appointed as the governor of Andhra Pradesh is not something unusual. In fact, this was also debated in the Constituent Assembly. In the Constituent Assembly, some members of the Constituent Assembly, particularly K.T. Shah, he moved an amendment in the Constituent Assembly that the judges, after their retirement, they should not be eligible for any government post. But this amendment was rejected by the Constituent Assembly. And there were two other individuals who rejected this proposal forcefully. One was Pandit Nehru. Pandit Nehru referred to Albert Einstein. He said, I don't know what is the exact age of Albert Einstein, but I'm sure he is above the age of 60. But to us and to the larger world, he is the most intelligent man on this planet. So a judge of the High Court who retires at 62, the judge of a Supreme Court who retires at 65, they still have the capability, the talent to serve the society. If we bar them from taking up any post-retirement job, it would lead to calamity, because the nation would be deprived of first-rate talent. And Dr. Ambedkar also said, judges, after their retirement, they can take up jobs as well. Why? Because it does not violate independence of judiciary. Why? Because the judges of the Supreme Court, after their retirement, they cannot practice in any high court. They cannot practice in the Supreme Court. But they can take up other assignments. Taking other assignments does not violate independence of judiciary. But then when this announcement was made, people referred to the previous statement made by former Finance and Law Minister, Mr. Arun Jaitley. Mr. Arun Jaitley had said, pre-retirement judgments are influenced by post-retirement jobs. So he was alleging that basically the judges give the verdict with the hope that they will get a favorable post-retirement job from the government. This practice should be ended because it violates the independence of judiciary. Particularly, people talked about some cooling off period. For example, they say it is okay to appoint Justice Fatima Bibi as the governor of Tamil Nadu. Why? Because she was not appointed immediately after her retirement. She was appointed 5 years after her retirement, which means this 5 year appeared as some form of cooling off period. That means the judges should have some cooling off period for a few years. After that, they can be appointed to the office of governor. But listen to me carefully. Justice should not only be done, justice should also be seen to be done. For example, we trust judiciary, and judiciary is giving important verdicts. We trust those verdicts with a hope that these judges are acting independently, without any fear, without any favor, particularly of the executive. Because independence of judiciary is part of the basic structure of the Constitution. If there is a cloud of suspicion on the judgment of an honorable court, then it would violate the trust that people have in the judiciary. There are critics who particularly say that Justice Nazir was part of the Ayodhya case. And in the Ayodhya case, he ruled by a majority that this 2.77 acres of disputed land in Ayodhya belongs to Lord Ram, which paved way for the construction of a mega Ram temple at Ayodhya. They say, who was the Chief Justice of India then? There were 5 judges on this panel. One was Justice Gogoi, against whom there were sexual harassment allegations. No action was taken against him, and in fact he was later, after his retirement, nominated to Rajya Sabha by the President. The other was Justice Chandrachud, who is now the Chief Justice of India. The other was Justice Nazir, who has now been appointed as the Governor of Andhra Pradesh. The other was Justice Bhushan, who within 4 months of his retirement was appointed as the chairperson of National Company Law Appellate Tribunal, and his appointment was cleared by the Appointments Committee of the Cabinet headed by the Prime Minister. And the last one was Justice Bobde, and they say next favor will be given to Justice Bobde. He is waiting in the wings, which basically means that Mr. Arun Jaitley, when he said pre-retirement judgments are dictated by post-retirement jobs, this practice shows the cloud of suspicion amongst the mind of the public, and they doubt the judgments given by the court. That is why justice should not only be done, it should be seen to be done. And that is why, to protect the independence of judiciary, the judges should be barred from taking any post-retirement job. Because even if this beautiful judgment in Ayodhya case, which resolved the decade-old dispute between the two communities, if this beautiful judgment is under the cloud of suspicion because of these post-retirement jobs, it violates the independence of judiciary. It sows the seeds of suspicion amongst the members of the community, amongst the members of the people of India, and should be desisted from. And at the same time, if at all judges are to be appointed, there should be a cooling off period. That means immediately after their retirement, they should not be appointed. Because if they are appointed, it gives a signal to the existing judges that if you favor the executive, if you toe the line of the executive, you will be favored suitably after your retirement. And this practice would violate independence of judiciary. So although appointing former judges as the governors is not unconstitutional, is not illegal, but should be desisted from in the larger interests of the judiciary. That is what you need to understand from this topic. Now let's look at topic number 4. Top court dismisses plea against Jammu and Kashmir delimitation panel. Listen to me carefully. August 5, 2019, Article 370, which provided some sort of special status to the erstwhile state of the Jammu and Kashmir, was diluted. How it was done? There is already a video available on our YouTube channel. Please go through that video lecture. August 6, 2019, Jammu and Kashmir Reorganization Act was passed. And this Jammu and Kashmir Reorganization Act created two union territories. Union Territory of Jammu and Kashmir, Union Territory of Ladakh. And this Union Territory of Jammu and Kashmir will have a legislative assembly. But this Jammu and Kashmir Reorganization Act also called for delimitation. And for that, a delimitation commission was set up. And then the delimitation commission gave its award as well. Then two residents of Srinagar in Jammu and Kashmir approached the Supreme Court. They did not challenge the dilution of Article 370. They did not challenge the constitutional validity of Jammu and Kashmir Reorganization Act. They did not even challenge the award which was given by the Delimitation Commission. They challenged the constitution of Delimitation Commission, saying Delimitation Commission should not have been set up. Why? Because when the rest of the country there is no delimitation, why are you singling out Jammu and Kashmir? And for that, let's understand this topic in slight detail. What is delimitation basically? Redrawal of the territorial constituencies, territorial boundaries. Constitution says after every census there should be delimitation. Every census, which is a decadal exercise conducted every 10 years, it tells us about the population of India. As the population increases, so should the legislators also increase, the number of legislators also increase. And this has happened. After the census of 1951, delimitation was conducted in 1952. After the census of 1961, delimitation was conducted in 1963. After the census of 1971, delimitation was conducted in 1973 as well. But when the delimitation was carried out in 1973, the southern states protested. Why? Because they alleged that you are basically disincentivizing the southern states and incentivizing the northern states. Why? After the census, when delimitation exercise is carried out, that means then redrawal of territorial boundaries will take place. That means on the basis of the population, although population is not the only criteria to carry out delimitation, but population is an important factor. As the population increases, the number of legislators will also increase. The number of Lok Sabha MPs will also increase. And it has happened. From 489, after delimitation, it went to 513. From 513, it went up to 543. That means after every census, when delimitation was carried out, it led to the increase in the number of seats in Lok Sabha. Clear? But the southern states protested, saying that we have implemented family planning programs effectively. And the northern states, the northern Bimaru states such as Bihar, such as Madhya Pradesh, such as Rajasthan, such as Uttar Pradesh, they have not effectively implemented the family planning programs, which means their population is still not stabilized, it is increasing. As their population increases, that means their representation in Lok Sabha would also increase, which means southern states will have less representation in Lok Sabha as compared to the northern states. Indira Gandhi was the Prime Minister. Constitution was amended. 42nd Constitutional Amendment Act was passed in the year 1976, which said no delimitation till 2000, which means till after the census of 2001. And all the seats shall be frozen till 2026. That means for 50 years, there will be no increase in the seats, whether to Legislative Assembly or to Lok Sabha, because we have a belief that in these 50 years, our population would stabilize. So if there is an increase, or if there can be an increase in the number of seats in Lok Sabha and state legislative assemblies, that can only happen after the census of 2026, which means can happen only after 2031 census. But no delimitation till 2000. That means after 2000 there can be delimitation. 2001 census was carried out, and 2002 delimitation was carried out. But what was that delimitation? It was basically internal delimitation. What is this internal delimitation? That means when the delimitation exercise was carried out in 2002, for that a delimitation commission was established in 2002, and it gave the final award in 2008. This delimitation was conducted for two reasons. Although the number of seats to Lok Sabha did not increase because it is frozen, the number of seats to Legislative Assembly did not increase because it is frozen till 2026. But then this delimitation was carried out for two reasons. Reason number one, there should be reservation for SCs and STs in proportion to their population. As the population has increased of the members of the SC and ST community as well, which means total number of seats will not increase in Lok Sabha, but the seats reserved for SCs and STs should increase in proportion to their population. That means this delimitation exercise, which was carried out in 2002, it did not increase the number of seats, but it increased the number of seats reserved for SCs and STs. That's number one. Number two, it was done internally. Internally in the sense, let's say there are 3 constituencies in a state X. 1, 2 and 3. In one constituency, there are 10 lakh voters. In second constituency, there are 30 lakh voters. And in the third constituency, there are 20 lakh voters. It violates one person, one vote, which basically means here 10 lakh people are represented by one MP. Here 30 and here 20 lakh people are represented by one MP, which means these voters, their value of vote is less as compared to the value of the vote of the people in first constituency. That is why in 2002 it was decided to reorganize the constituencies internally. Internally how? So that we can divide For example, total would be 60 lakh voters, and in constituency 1 we will have 20 lakh voters, constituency 2 20 lakh voters, constituency 3 20 lakh voters. So that one person, one vote is adhered to. And that is why delimitation was carried out in the year 2002. The final award was given in 2008. But this delimitation was not conducted in 4 northeastern states. Which are these states? States such as Assam, states such as Arunachal Pradesh, states such as Nagaland, and the state Manipur. Why? Because these states, they said, please do not conduct delimitation based on 2001 census, because there has been a lot of illegal migration which has taken place. And if you reorganize our states based on 2001 census, we doubt the credibility of the census. That is why the President of India issued an order and excluded these 4 states from delimitation exercise. When excluded these states from delimitation exercise, President further said that if delimitation is to be conducted and carried out in these 4 states, it should be carried out by Election Commission of India and not the Delimitation Commission. But then, when in the year 2020, Delimitation Commission was set up, this Delimitation Commission was asked to conduct delimitation in Jammu and Kashmir as well as in these 4 northeastern states. But then the question was raised that President's order said delimitation in 4 states should be carried out by Election Commission of India and not the Delimitation Commission. So that is why there was a conflict. And then by a subsequent order, the government said, no, this Delimitation Commission will carry out delimitation exercise only for Jammu and Kashmir and not for these 4 northeastern states. And that is why 2 residents of Jammu and Kashmir, they challenged this Constitution of Delimitation Commission. And there the Supreme Court dismissed this petition. And for that you need to understand something known as presumption of constitutionality, or the doctrine of the presumption of constitutionality. What does that mean? The Supreme Court said the petitioners have not challenged the Jammu and Kashmir Reorganization Act. When you have not challenged it, we will assume that this law is constitutional. Because we always start with this presumption that the law is constitutional. It is for the petitioner to decide, it is for the petitioner to prove that this law is unconstitutional. So you have not challenged the dilution of Article 370. You have not challenged the Jammu and Kashmir Reorganization Act. So for us, Jammu and Kashmir Reorganization Act is constitutional. And it is this law which provides for Delimitation Commission. And when the law provides for Delimitation Commission, we cannot stop it. That's number 1. Number 2, the petitioner said if in the rest of the country there can be no delimitation, there can be no increase in the number of seats, how can the Delimitation Commission for Jammu and Kashmir increase the number of seats in Jammu and Kashmir as well? The court said there is a difference. Others are states. Jammu and Kashmir right now is a union territory. So for union territory, there can be delimitation and there can be increase in the seats as well. The court further said that if these 4 northeastern states are excluded, it does not violate Article 14. Because Article 14 talks about equal protection of the law. Article 14 says unequals cannot be treated equally. In a sense, likes are to be treated alike. Unlikes cannot be treated alike. There are these 4 northeastern states which have challenged, which have raised objections regarding the census of 2001. So there the condition is different. And Jammu and Kashmir's condition is different. So J&K cannot be equated with these 4 northeastern states. Your petition is dismissed. The petitioners also said that if delimitation is carried out, last time it was carried out on the basis of 2001 census, why in Jammu and Kashmir you are carrying out delimitation on the basis of 2011 census. The Supreme Court even dismissed this position, saying under Article 3, when the Parliament has the power to create a union territory, it may also call for the reorganization, which means delimitation. And that delimitation can be on the basis of the previous census. And the previous census was in 2011. So there is nothing illegality about the Delimitation Commission. That is what you need to understand from this topic. Top court dismisses plea against Jammu and Kashmir Delimitation Panel. Clear? Let's look at another topic, the missing deputy speaker. Constitution says that after the general election, the House of the People, which is Lok Sabha, it shall elect two people or two MPs from amongst themselves, one as the speaker, the other as deputy speaker. And the Lok Sabha shall elect as soon as may be. What does the Constitution say? That after the general election, Lok Sabha will elect two members from amongst itself, one as speaker, one as deputy speaker, as soon as may be. And the similar provision is for the Legislative Assembly as well. Legislative Assembly, when it was constituted, the members of the Legislative Assembly will elect one MLA as the speaker, the other as the deputy speaker, as soon as may be. But the Lok Sabha election was conducted in 2019. We are in 2023 and there is no deputy speaker. Similarly, there is no deputy speaker in Rajasthan, in Uttarakhand, in Uttar Pradesh, in Madhya Pradesh, in Jharkhand. A public interest litigation was filed, and now the Supreme Court will have to decide on this matter whether an order, a directive, a ruling should be issued so that the Lok Sabha and these legislative assemblies should elect their deputy speaker. This deputy speaker, when Constitution says shall, it means it is mandatory for the Lok Sabha to elect a speaker as well as the deputy speaker. But when the same Constitution says as soon as may be, which means there is no time limit within which the speaker and the deputy speaker should be elected. So whether there should be a time limit, that's for the court to decide now. That's another issue. How was this post of deputy speaker envisaged? The speaker remains in office normally for the entire term of the Lok Sabha, but the speaker can be removed as well, or the speaker can resign as well. Speaker submits his resignation to the deputy speaker. Deputy speaker submits his resignation to the speaker. So speaker and deputy speaker, they resign by submitting resignations to each other. In the Constituent Assembly, it was argued that speaker should be sending resignation letter to the President of India. Because if the speaker is sending the resignation letter to the deputy speaker is a subordinate of the speaker. So normally, somebody who appoints you should remove you, or somebody superior to you, you can send resignation to that superior. If the speaker is sending resignation to the deputy speaker, who is considered to be subordinate of the speaker, this doesn't bode well. That is why there was a suggestion that speaker should be sending his resignation to the president. But the Constituent Assembly rejected this. Dr. Ambedkar rejected this, saying speaker is elected by Lok Sabha. Deputy speaker is also elected by Lok Sabha. So if Lok Sabha is appointing you, you have to send your resignation to Lok Sabha as well. But it is not possible for the speaker to send his resignation to individual MPs of Lok Sabha. So what Lok Sabha speaker will have to do? Submit his resignation to the deputy speaker, because deputy speaker is also elected by the Lok Sabha. And that is how the post of deputy speaker was envisaged. And normally, although it is not mentioned in the Constitution, but it's a convention. Convention is unwritten rule. That means something which is not mentioned anywhere, but something that we follow. And what do we follow? The speaker is generally from the ruling party or the ruling coalition. And the deputy speaker's post normally is given to the opposition Although it's not mentioned in the constitution, but this is an unwritten rule that we have been following for a long time. And that is perhaps the reason why we don't have a deputy speaker. The government is asked, why don't we have a deputy speaker? The government says, go and ask the speaker. According to the rules of the Lok Sabha, the date of the election of the deputy speaker will be fixed by the speaker. Speaker says there is no urgency to have the election for the deputy speaker. Why? Because we are running the business as usual, bills are getting passed, the discussion is happening in the Lok Sabha, so there is no urgent or immediate requirement to elect the deputy speaker. And in any case, we have a panel of chairpersons. What is the panel of chairpersons? If the speaker's office is vacant, deputy speaker's office is also vacant, then who will preside over Lok Sabha? For example, the speaker is absent. In his absence, who presides over the Lok Sabha? Deputy speaker. If there is no deputy speaker, then who will preside over Lok Sabha? A panel of chairpersons. And these panel of chairpersons, they belong to various political parties. Rules say not more than 10 members of the Lok Sabha can be appointed, can be nominated to this panel. And right now we have 9 members on this panel. So in absence of the speaker, one amongst these 9 panel of chairpersons, they are presiding over Lok Sabha. So there is no immediate requirement to hold and organize the election to the post of the deputy speaker. And at the same time, courts are prohibited from going into the procedures of the parliament. Procedures of the parliament in the sense, can the court dictate to the Lok Sabha that you should elect a deputy speaker? On that, there is a conflict, different opinions by different constitutional experts. One set of experts say courts cannot dictate terms to the legislature, to the Lok Sabha, because courts are prohibited from interfering with the procedures of Lok Sabha. For example, how a bill was taken up for discussion, whether opposition was given the opportunity to participate in the debates, whether sufficient time was given to the parliament to debate a particular bill. On these, there can be no challenge before the court, because courts are prohibited from interfering in the procedures of the legislature. Separation of powers. But other set of constitutional experts say that when the constitution says that the Lok Sabha shall elect a deputy speaker, this term shall makes it clear that if we do not have a deputy speaker, it means there is violation of the letter and spirit of the constitution. And on that ground, the Supreme Court can interfere and direct the Lok Sabha to elect the deputy speaker. That is what you need to understand from this topic. Now let's look at some of the prelims based questions. 1. Speaker of Lok Sabha, deputy speaker, who presides over the joint sitting of the two houses? For example, on a particular bill, if there is a deadlock, one house agrees with this bill, the other house does not agree. That means on this bill, there is a deadlock. And to resolve this deadlock, there is a provision called joint sitting of the two houses, where Lok Sabha and Rajya Sabha, they come together jointly and resolve this deadlock. But because of the numerical strength of Lok Sabha, because Lok Sabha has 543 MPs, Rajya Sabha has 245 MPs, because of the numerical strength of Lok Sabha, it's the will of the Lok Sabha which prevails in this joint sitting. But who presides over this joint sitting? The Speaker of the Lok Sabha. But if he or she is not present, then Deputy Speaker of the Lok Sabha. If she or he is not present, then the Deputy Chairperson of Rajya Sabha. If he or she is not present, then any member who is elected or who is decided by consensus at this joint session, that person presides over the joint sitting, which means under no circumstance does the chairperson of Rajya Sabha preside over joint sitting. Because the chairperson of Rajya Sabha, who is the Vice President of India, is not the member of the Rajya Sabha. When he is not the member of the Rajya Sabha, he cannot preside over the joint sitting of the two houses of the Indian Parliament. The question is asking, arrange the above in terms of the sequence to be followed for presiding over a joint sitting of the two houses of the parliament? The answer is D, none of the above. Because when you include 3, which is the chairperson of Rajya Sabha, he never presides over Rajya Sabha. And he never presides over the joint sitting of the two houses. So chairperson of Rajya Sabha is not part of the sequence. That is why D, none of the above, is the right answer. Question number 2. According to Constitution, a governor shall hold office for a term of 5 years from the date on which he enters upon his office. Yes, this term is mentioned in the Constitution. But at the same time, we say that the governor holds office during the pleasure of the president, which means the governor does not enjoy security of tenure. Although the Constitution says that the governor shall hold office for 5 years from the date he or she is appointed, but he can be removed, he can be transferred at any point in time depending upon the pleasure of the president, which basically means the pleasure of the Prime Minister and his Council of Ministers. But this statement is correct because according to the Constitution, a governor shall hold office for a term of 5 years. The copies of the orders of the Delimitation Commission are laid before the House of the People and the State Legislative Assembly concerned, but no modifications are permissible therein by them. Constitution says under Article 329 that courts are prohibited from dealing with the electoral matters. For example, one such matter is delimitation. The award given by the Delimitation Commission cannot be challenged in any court of law. Then you might say, sir, what happened in the Jammu and Kashmir case? I told you specifically, categorically, explicitly that this judgment, that this case did not challenge the award given by Delimitation Commission, because the Delimitation Commission increased the number of seats to Jammu and Kashmir Legislative Assembly. 6 seats were given to Jammu region, 1 seat was given to the Kashmir region. But this was not challenged. What was challenged? The very constitution of Delimitation Commission, saying there should be no delimitation when in the rest of the country it is not happening. Why single out Jammu and Kashmir? When in the 4 northeastern states it did not happen, why single out Jammu and Kashmir? But this award of the Delimitation Commission cannot be challenged before any court of law. So that is correct. The doctrine of essentiality was invented by the Supreme Court in the Keshavananda Bharti case of 1973. Now it was invented by the Supreme Court in the famous Shurur Mutt case of 1954. Select the correct answer. Only 2 statements. B is the correct answer. 2 mains-based questions. The essentiality doctrine, the doctrine innovated by the Supreme Court called ERP, Essential Religious Practices Doctrine. It has tended the court to lead into an area that is beyond its competence and given judges the power to decide purely religious questions. This doctrine has been criticized by various constitutional experts, saying that it has given power to the judges to decide the questions related to religion. The judges may not be competent to decide what are essential features of a religion, what are not essential features of a religion. For example, in Ananda Margi case, the Supreme Court said Tandava dance is not the essential religious practice, although the founder clearly talked about the Tandava dance. In various other cases, the court has said that mosque is not an essential religious practice of Islam. That means it has tended the court to decide questions which are purely religious in nature, which they may not have competence to do. Question number 2, the role of Election Commission of India is not restricted to holding of elections to Lok Sabha and state legislatures. Discuss. And we have discussed 2 other roles. Resolving the factional dispute as to which faction is the real party and will get to control the symbol and the name, and also to advise to send report to President and the Governor regarding some disqualifications. And now the last segment, watch out. Number 1, first start with number 2, assembly elections in the 3 northeastern states of Tripura. Elections have been conducted. Now elections will be conducted on I think 27th of February to Nagaland and the Meghalaya Legislative Assembly. Watch out for these results. Watch out for Nota. What is the percentage of people who voted for Nota in these elections? Watch out also if after the election there is violation of anti-defection law of 1985. That's something that you will have to watch out for. Second, plea to revisit the correctness of the Constitution Bench judgment in Nabam Rabia versus Deputy Speaker 2016. Something happened in this case. What happened? The governor had preponed, the governor of Arunachal Pradesh preponed the Legislative Assembly's session. This was challenged in the court. The Supreme Court said preponing is not the discretion of the governor. The governor can summon the Legislative Assembly only on the advice of the Chief Minister and his Council of Ministers. That was number one. Number two, in this case, it was told by the Supreme Court, 5-judge bench of the Supreme Court, that a speaker who has the authority to decide on disqualification petitions under anti-defection law. Because if a legislator has violated anti-defection law, he or she can be disqualified. By whom? By the speaker. But in Nabam Rabia case, the Supreme Court, the 5-judge bench of the Supreme Court said, if a proceeding is against the speaker, that there is a motion which is pending in the Legislative Assembly calling for the removal of the speaker, when there is a cloud on the speaker cannot act as the body to disqualify members under anti-defection law, which basically means if there is a motion pending in the Legislative Assembly calling for the removal of the speaker, now the same speaker cannot disqualify a legislator under anti-defection law, because first he has to be elected, he has to be ratified, his election has to be ratified. If he is removed as the speaker, then he cannot act on the disqualification petition. But now in this case, Shiv Sena versus the factions of the Shiv Sena case, the lawyer representing Uddhav Thackeray faction, Kapil Sibal, he approached the Supreme Court and said, this judgment needs a revisit. Why? Because now something reverse is happening. Legislators should be disqualified under anti-defection law because they have violated the whip of the political party or they have rebelled against the political leadership. Now, to save themselves from disqualification under anti-defection law, they introduce a motion calling for the removal of the speaker. So now the speaker, because of this judgment, is not in a position to disqualify them, because he is barred by Nabam Rabia judgment from disqualifying legislators on the ground of defection. The Chief Justice of India agreed that yes, it raises a difficult constitutional question. But if he allows speaker to disqualify them, the speaker may be biased. If we do not allow the speaker, then it basically leads to a situation where there can be a government which does not have the majority. There can be a political party which has lost control over its flock, yet is continuing to form the government. But the Supreme Court said we will hear this matter on February 21. On merits, we will hear this case and then we will decide on February 21 whether this Nabam Rabia judgment should be referred to a larger 7-judge bench of the Supreme Court to decide these difficult constitutional questions. So watch out for this case, hearing on February 21, and then let's see what the Supreme Court had to say on this matter. That is it for today. We discussed close to 5 topics, 2 MCQs, 2 mains-based questions, and 2 watch-out sections. Thank you so much for staying with us. See you again next Saturday at 8 o'clock and discuss other important set of topics in this segment, Polity This Week. Good night.